Good evening. Happy Monday. I am having a glass of bourbon, and I think you should have a glass of bourbon along with me. Delicious. So, on November 5th, I made a video critiquing CJ Chickenhawk Grisham, also known as Tiny Grisham, his interactions with the police and with clients, or maybe not clients, I'm not entirely sure, in a traffic stop that he was recording. And I guess today he decided that he wanted to, or maybe yesterday, he decided he wanted to start piping up. So he said, apparently, some loser attorney in California who has a man crush on me. I like really tiny men. Posted an ignorant and legally deficient analysis of my arrest. So we know that he has already been able to make a determination by viewing the video that it was ignorant and legally deficient. But then he continues, number one, no, I don't care to see it. Kind of makes your analysis a little suspect then, if you actually haven't seen the video and yet it's ignorant and legally deficient. Number two, MERB isn't worth my time. A 2 hour and 6 minute and 39 second live stream today. I'm going to suspect that I am worth your time. Big boy. Well, tiny boy. Number three, he's just jealous that I am financially stable enough to be an attorney and an activist. While he's likely paying off his law school debt that supposedly didn't help him pass the bar the first time. I have zero debt and have a life holding tyrants accountable. It's easy being a pussy. Standing for something is hard. So I said, first you'd have to be a man. I'm sorry. I know. I like to poke and prod. At best, I could have a manlet crush on you, Tiny. Also, debate me. Show me how ignorant and legally deficient my analysis is. And then kissy face. Gotta have kissy face in there, right? Well, apparently that wasn't, he didn't want to debate me, but he did post a new one. This was today. He said, all these people in comments telling me that I should debate MERB. On what? Previously, I had asked him to debate me on suing a judge, and now I want to debate me on whether or not it's legally, how ignorant and legally deficient my analysis was that you hadn't even bothered to watch. For what purpose? Well, I like to educate my audience. I like to give people a little insight onto how an attorney thinks about certain things, about the thought process, the steps. People seem to like that. Is that a good purpose? You might as well ask me to debate a rock. Well, I am a rock star. I'm internet famous. I've got like 5,000 subscribers. I'm big time. I'm ballin'. How am I supposed to know about a debate when I don't ever look at her channel? You get that? Did you get that? Did you get that subtle dig, folks? I'm a her. She obviously looks at mine, but hasn't said a thing here. Actually, I got all of these because they were posted in my Discord. Other people wanted me to look at them. Believe it or not, I'm not subscribed to CJ Grisham. I have made videos about him in the past a long time ago when he said silly things. And, when you say something that's interesting to me, I'm more likely to comment on it, to make a video about it if I think it's interesting. I don't generally make a video on something unless there's some legal aspect to it that I can take apart, look at, maybe put back together. I'm kind of like a crackhead, except with legal research. I like to do it. It's kind of my thing. How am I supposed to know about a debate when I don't ever look at her channel? I I was half tempted at this point to go through and pull up all the comments that he had put on my videos in the past, but I decided not to. I don't think it really changes anything. I mean, it's whatever. I mean, if he doesn't watch my videos, fine. If he does, fine. I get it. He's trying to minimize me. Um, Whatever. I mean, I'm easy peasy lemon squeezy. She obviously looks at mine, but hasn't said a thing here. Well, I don't always comment on other people's channel. I did comment on your live stream today, but I quickly realized that you weren't going to turn it into a debate. You were just going to ignore my relevant points and march along to your own drum. I'm fucking busy doing legal stuff. I hate it when I'm fucking busy doing legal stuff. In fact, during the mid part of your live stream, I had to do a case management conference. So, yeah, that sucked. A case management conference is basically when you go to court, you sit there for like an hour waiting for your case to get called. You go up there and you say, yes, Your Honor, we need 90 more days or whatever before we set this for trial. So can you give us 90 more days? And the court's like, okay, or no, or whatever. It's pretty boring. How does she have time for debate anyway? Well, sir, you had 2 hours plus to make a video, so I'm going to suggest we could have had a debate. Now, for those of you who are thinking, a debate, the way I view it, any debate that's actually worth anything to the viewer is one where there's going to be a moderator who's going to act like a judge, preferably someone who knows the law, preferably someone who can understand legal arguments. So I would suggest, if we do a debate, I would love to debate you on any of the topics that you've raised, CJ, or any of the topics that I've raised. I would suggest an attorney. We have lots of attorneys on the internet with lots of channels. I'll let you pick the attorney. Well, how about you give me three attorneys and I'll pick one of them? Or in the alternative, I'll give you three and you could pick one of them. And we each present our various cases to the attorney, who can act kind of like a judge, and then the attorney will say who he thinks wins. And that doesn't, just so everybody's aware, that doesn't mean that the attorney is going to make the right decisions, because you got to remember that, judges make decisions all the time, and appeals court judges oftentimes tell them they're wrong. And Supreme Court judges oftentimes tell appeals court judges that they're wrong. And Supreme Court judges oftentimes write dissent, or appeals judges oftentimes write dissents, where they disagree with other people who are in their same court. So judges can have differences of opinions. So just because we have an attorney pick one side or the other doesn't necessarily mean that that's the way it would play out in court, but I'm reasonably confident enough in my positions that I have a feeling that a trained attorney, a neutral trained attorney, would most likely think that what you're spitting is pure nonsense and what I'm spitting is reasonably close to fact. So anyway, 2-hour video. I didn't watch all of it. I watched some at the beginning and some at the end. I came in when CJ was going on about 42 USC 1983. Apparently, this is the route that he's going to sue the judge under. Now, to lay the background, because none of my critique of him wanting to sue the judge came about in a vacuum. It came about in response to facts that he alleged and that I responded to. The facts that he alleged, as I remember them, and I could be wrong on these, so take this with a huge grain of salt, was that he was, quote, representing, end quote, a client, i.e. the attorney who's sponsoring him was there and allowing CJ to make an argument, a motion before the court to have the client's firearm returned. Apparently, the client had either been found not guilty or the charges had been dismissed. I'm not sure which. It doesn't really matter for the purposes of this, for the purposes of determining the relevant facts. So CJ made his motion. He pointed to a section of Texas law that mandated the return of the firearm. And the judge said no. The judge denied the motion for the return of the firearm. And instead of appealing, CJ said that in November, he would file a lawsuit against the judge to get the firearm back. Apparently the firearm had some sentimental value to the client. I don't remember if it was a gift from his father or something, but it was apparently a sentimental value kind of thing. I don't remember exactly why. I don't think it's really important, but he was going to sue the judge to get the firearm back. So now he's pointing at 42 U.S.C. 1983. For those of you who aren't aware, 42 U.S.C. 1983 allows you to sue for a deprivation of any of the rights, privileges, or immunities secured by the Constitution and laws of the United States. So remember, he was talking about a state law that required the judge to return the firearm, and now we're in a 1983 lawsuit which deals with federal laws. So that's weird. Imagine my surprise. And then he's pointing to this particular section for how he's going to do it. In any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or a declaratory relief was unavailable. I'm going to take another sip of whiskey. So what that is saying that if declaratory relief is available, you can't get injunctive relief. If declaratory relief is unavailable, you can sue for injunctive relief, okay? Now, when is injunctive relief available and declaratory relief not available? Well, that's not a very common thing. Declaratory relief can be like somebody did something to you, or somebody's engaged in a practice of doing something, and you want declaratory relief. You go to the courts, you file your lawsuit, and what you're seeking is to have the court say, that person is doing a wrong thing. That person is, violating your Fourth Amendment right. Let's say that every day you go to get on the bus, and the bus is owned and operated by the city. So a city employee, the bus driver, pats you down every day as you get on the bus. Let's just say that's what's going on. And you want to sue for declaratory relief. You want the court to say to the city, and specifically to that bus driver, that it's a violation of the rider's Fourth Amendment rights for them to be patted down every day getting on the bus. That's the declaratory relief that you're seeking. It doesn't compensate you for past pat downs. It doesn't return any items that were confiscated by the bus driver. It just says, you can't do that anymore because that's a violation of people's rights. That's declaratory relief. Injunctive relief is really what he's looking for. Injunctive relief is return the firearm. Return the firearm. That's what he's looking for. And injunctive relief isn't available if there's declaratory relief. The declaratory relief could be you violated his, Second Amendment right by not returning the firearm. So remember we're operating under the facts as alleged by CJ. So we don't have all of the facts. I'm sure the court gave some rationale that we don't have as to why the court wouldn't return the firearm. But we're just operating under the facts as alleged. CJ is going to sue the judge, and now it's for injunctive and or declaratory relief. So how do we analyze that? Well, first there's Bolin versus Story. Now, Bolin versus Story deals with a with some criminal defendants who were convicted, and they thought that it was bullshit how they couldn't challenge the judges. And the court said, this is 11th Circuit Court of Appeals, as discussed below with regard to the defendant prosecutors, plaintiffs are not entitled to declaratory relief as there is an adequate remedy at law. Therefore, for this reason as well, the district court properly dismissed plaintiffs' claims against the defendant judges. So for the same reason as given in Section D, the claims against the judges were dismissed. So if there's an adequate remedy at law, what's an adequate remedy of law? Well, let's figure it out. In order to receive declaratory or injunctive relief, plaintiffs must establish that there was a violation, that there is a serious risk of continuing irreparable injury if the relief is not granted, and the absence of an adequate remedy at law. As aptly noted by the Ninth Circuit in Mullis, there is an adequate remedy of law for the violations alleged by plaintiffs in their complaint. Specifically, plaintiffs may appeal any rulings or actions taken in their criminal cases, not only to this court but to the Supreme Court. In addition, plaintiffs may seek an extraordinary writ, such as a writ of mandamus, in either this court or Supreme Court. Accordingly, there is an adequate remedy at law, and plaintiffs are not entitled to declaratory or injunctive relief in this case. So this was in district court. This was a violation of they were alleging a violation of the rights done by the district court in a criminal action. So they sued in the district court for a civil action, and that's why they're talking about writs to this court or the Supreme Court. The adequate remedy at law would have been for Tiny Grisham and his client to appeal the ruling or seek a writ of mandamus. And there may not be time left to do that. I think normally you have about 60 days or so. And I don't remember how long it's been, but it would be a real shame if he let it pass. So anyway, that's a real problem for him, right? And then this is Martin v. Heffelfinger. This basically the same thing. It's just a state court judge. And you have to have no adequate remedy at law. And yeah. However, Martin, who's the plaintiff, must prove that his remedies at law are inadequate before he can state a claim for equitable relief. See blah, 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 holding that plaintiffs cannot seek declaratory or injunctive relief against judges where there's an adequate remedy at law, noting that well in the past under Pulliam. So, speaking of Pulliam, Pulliam was a Supreme Court decision that said that you can get injunctive relief in a 1983 lawsuit against a judge. That was done and that was passed, that ruling came down in 1984. In 1996, you'll see the FICA took that away. So there was a statutory change that no longer allows you to get injunctive relief. And then there's Hoppenstein versus Ruckel. This is out of Texas, Eastern District of Texas, 2015. Neither injunctive relief nor monetary damages are available in the Section 1983 action against a state judge. However, plaintiff also seeks declaratory relief. So you could seek declaratory relief. They cite Lawrence v. Kuhnhold. Lawrence v. Kuhnhold is this bad job or do. The only type of relief available to a plaintiff who sues a judge is declaratory relief. But not every plaintiff is entitled to this remedy. You have to specify the form declaratory relief would take, and your complainant has to request declaratory relief in a true legal sense. A declaratory judgment is meant to define the legal rights and obligations of the parties in anticipation of some future conduct not simply to proclaim liability for a past act. A declaratory judgment action involving past conduct that will not recur is not justiciable, i.e., unless Tiny Grisham can make a argument that the courts will buy that there's some ongoing thing with this court not returning firearms in violation of Texas state law. Well, again, I don't think that there's a case or controversy under the Constitution of the United States or the laws of the United States that will get you a 1983 action, but what do I know? And then finally, there is Reynolds versus DeLarge. This is out of Eastern District of Louisiana. Louisiana is Fifth Circuit. And this talks about the Federal Courts Improvement Act, FCIA. For more than 100 years, judges have been held immune from liability for judicial acts done within their jurisdiction. Citations. A judge of whatever status in the judicial hierarchy is immune from suit for damages resulting from any acts performed in his or her judicial role. Citations. This judicial immunity applies even if a judge is accused of acting maliciously or corruptly. Citations. Judicial officers are absolutely immune from liability for damages unless they are without jurisdiction. Citations. In the past, however, judicial officers did not enjoy absolute immunity from suit-seeking injunctive relief. Relief of that nature was available under Section 1983 against state court judges acting in their judicial capacity. This is a citation to Pulliam. That was the 1984 Supreme Court case I told you about. However, the Federal Courts Improvement Act of 1996, FCIA, amended Section 1983 to provide that in any action brought against a judicial officer for an act or omission taken in such officer's judicial capacity, injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief is unavailable. The FCIA therefore statutorily overruled Pulliam's holding regarding the availability of injunctive relief against a state judge in his official capacity. Citations. Thus, neither injunctive relief nor damages are available in this Section 1983 action against a state officer. Citations. Furthermore, to what extent, if any, that a plaintiff seeks an order directing a judge to take an action concerning the plaintiff's state court proceedings, this is where it gets spicy, a federal court has no power to direct a state court or its judicial officers in the performance of their duties when mandamus is the only relief sought, i.e., the federal court has no power to tell the state court judge to give your client back his gun. That's mandamus. Mandamus, think of it like mandate, telling someone to do something. This is now mandatory. A writ of mandamus tells a court to do something. A federal court is without authority to order, and look at all the citations, by the way. A federal court is without authority to order officials of the state court having jurisdiction over a plaintiff's criminal case to treat his claims in any particular way or to otherwise interfere with the rulings of its judges. Citations. And now it's time for a sip of bourbon. So you can see, or at least I hope you can see, that I don't think he really understood what he was looking at when he read 42 U.S.C. 1983. I think he saw this as giving injunctive relief, as making a channel to get injunctive relief, not as cutting off injunctive relief. And I'm not entirely sure he understands what declaratory relief is. Anyway, I think I've made it pretty clear that his lawsuit against the judge is still doomed to fail, even with his misunderstanding of 42 U.S.C. 1983. Now, with the confidentiality of information, I caught in the car, so I wasn't listening super close, but he doesn't think that him broadcasting a conversation with someone who might be a client, well, first of all, it's a real problem if you think the person might be a client. You should know who your clients are and are not. That's just rule number one. But confidentiality of information is one of those big bugaboos that at least California State Bar really, they really get, they really don't like you to talk about your clients, to give away client information. And it can be something like when attorneys listen to attorneys on YouTube, listen to other attorneys on YouTube, when they talk about things that they've done for their clients, etc., they don't identify their clients. They don't identify the names of their clients, generally speaking. I mean, you'll get a couple who will say, so and so was my client, so and so was my client. But a lot of times, if they're telling a story about what someone did or didn't do, like where there's a, my client at court said this, and that. They won't identify the client, right? Even though the client said something in open court, they won't identify the client. And there's a reason for that, and it's because you don't want to get close to the line with the state bar. You don't want to get close to the line with the state bar. Just trust me on that. You don't want to get that letter from the state bar where they tell you to turn over your client file and they give you a list of questions that they want answers to, and you're obligated to give them answers. You're obligated to cooperate. So I'm not saying, and I didn't say then, and I'm not saying now, I'm not saying that he violated the rule about confidentiality. I'm just saying that there's a very real possibility he might have, or that he would have had he not been arrested, because he was still recording up until the cop came up and basically started to arrest him. So it's just concerning to me. But let's look at the actual rule. This is from Texas State Bar. This is Rule 1.05, Confidentiality of Information. Confidential information includes both privileged information and unprivileged client information. Privileged information refers to the information of a client protected by the lawyer-client privilege of the various rules. Unprivileged client information means all information relating to a client or furnished by the client other than privileged information acquired by a lawyer during the course of or by reason of the representation of the client. It could be things you didn't even get from the client. Except as permitted by paragraphs C and D or as required by paragraphs E or F, a lawyer shall not knowingly reveal confidential information of a client, which, remember, can be privileged or unprivileged client information, to anyone else other than the client's representatives, or the members, associates, or employees of the lawyer's law firm. So broadcasting it to the world on YouTube is, I mean, take this for what you will. It's just probably not a good idea. You probably don't want to do that. Now, I was critiquing his actions, not the actions of the Mongols, or the people who were stopped, who may or may not have been Mongols. But Mongols are classified by the Department of Justice as a outlaw motorcycle gang, and Texas classifies them as a gang. Texas Gang Threat Assessment, Department of Public Safety. Mongols are a gang. They're OMG, Outlaw Motorcycle Gang. Now, he did present this case. This is Terry Martin versus the state of Texas. And he seemed to think it was really important, and I don't really think it was. Here's the crux of the issue for me. The crux of the issue for me, as was laid out into this, in this case, was dealt with two penal code provisions. One was 7101D, and the other one was 46.02 A1 2C. Those are the two penal code sections that this opinion was dealing with. The guy was a member of the Cossacks, and he got popped with a firearm, and because the prosecution said, well, he's a member of a criminal street organization or criminal street gang, That's 7101D. Criminal street gang means 3 or more persons having a common identifying sign or symbol or an identifiable leadership who continuously or regularly associate in the commission of criminal activities. Okay. And 46.02A1 to C says a person commits an offense if the person intentionally, knowingly, or recklessly carries on or about his or her person a handgun, a motor vehicle, or watercraft that is owned by the person or under the person's control at any time in which the person is a member of a criminal street gang as defined by section 71.01, which we just read. Now, the court looked at a past case. It was in re ex parte Flores. There we go. And we want to go up to where they first talk about ex parte Flores. All right. Under 71.01D, a criminal street gang is identified as 3 or more persons having a common identifying sign or symbol or an identifiable leadership who continuously or regularly associate in the commission of criminal activities. In ex parte Flores, the 14th Court of Appeals held that when read together, that is important language, the provisions of 71.01D and section 46.02A1 to C indicate that a gang member must be one of the 3 or more persons who continuously or regularly associate in the commission of criminal activities. So, in order for you to get popped with a firearm as a member of a criminal street gang, as defined by 7101D, criminal street gang means 3 or more persons, you have to be one of the 3 or more persons who continuously or regularly associate in the commission of criminal activities. Makes sense. Makes sense. You can't just be a gang member who isn't like an active gang member and all of a sudden you can't carry your firearm anymore. You have to be one of the 3 or more people. You must be one of the 3 or more people who continuously or regularly associate in the commission of the criminal activities. But it's only when read together. It is literally only when read together. And this court affirms that. This court affirms that. We agree with the appellant. To be a gang member for purposes of prosecution under the statute. What statute? 46.01, or excuse me, 46.02, A1 to C. An individual must be one of 3 or more persons with a common identifying sign, symbol, or identifiable leadership, and must also continuously or regularly associate in the commission of criminal activities. That was the holding of ex parte Flores, and they agree. And they found that while the evidence establishes the first half of the equation, i.e. appellant's membership as a Cossack, so they're saying that they are this half. Cossacks are a street gang. They are a criminal street gang. But the individual must also continuously or regularly associate. That's what the prosecution failed to prove in Martin versus the state of Texas. So under ex parte Flores, both gang membership and criminal conduct are required. So the Cossacks are a criminal gang. That's what this court held. That's what this court held. I don't know how Mr. Grisham didn't get that, didn't understand that. I guess he said he had a whole bunch of stuff highlighted. I was driving at the time, so I was just listening. I wasn't watching, but he said in the video that he had a whole bunch of stuff highlighted. And I don't know what the hell, I don't know why he wouldn't understand that. Now, this case is also even further useless to him, because why wouldn't it be? But 46.02 A1 2C was removed. It is no longer included in the statute as of September 1, 2021. And add to that fact, there wasn't a firearm issue in the traffic stop. So I am literally boggled as to what Grisham thought he was going to prove to the cop by pulling out Martin versus State. I'm boggled. Number one, you don't argue case law on the side of the road. Number two, you shouldn't argue case law that you don't freaking understand. And if you do argue it in court where you have a judge. That was the point I was trying to make. I didn't expect him to actually provide me with the case and be that wrong on it. I fully expected that there was a case out there that said the Mongols aren't a criminal, a criminal street gang. I fully expected him to have a case on point. I mean, color me shocked. I don't know how I got through legal research in law school, but I guess he did. So, congratulations to him. Anyway, this has been long enough. I don't want to hit 2 hours. Thanks for watching. Have a great day.